President Goodluck Jonathan assented to the Administration of Criminal Justice Bill on the 14th of May 2015. The act merged the provision of two principal legislation, the CPA and the CPC, into one principal federal act, which is intended to apply uniformly in all federal courts across the entire federation and at the same time also preserve the existing criminal procedure rules. On the program today, we will do a more in-depth look at some of the innovations of the ACJ Act. Welcome to Law Weekly on Channels Television. I'm Victoria Idowu. On the program today, we will take you back to our earlier discussion on the Administration of Criminal Justice Act signed by former President Goodluck Jonathan at the end of his administration. We also spoke to some lawyers on the recent appointments by President Muhammadu Buhari and whether the issue of federal character applies at this point. But before we proceed, let's take some stories.
After 4 days of recess, the Akwa Ibom State Election Petition Tribunal reconvened with the People's Democratic Party and the Governor of the state, Mr. Udom Emmanuel, opening their defense. Led in evidence by Mr. Paul Usoro, counsel to Governor Emmanuel, the first witness, named Paul Bassi, polling agent of the PDP, denied allegations of ballot box snatching and any form of violence. He told the tribunal that results were collated from all the 14 units in Uyo local government area, except in 3 units where he admitted that the election could not hold because of violence. He also stated that all efforts to conduct accreditation by the officials of INEC failed. However, under cross-examination by Chief Wale Olanipekun, counsel to the petitioners, the witness read out 9 results from different units signed by one Joseph Okon Peter. However, the Attorney General of Akwa Ibom State and the counsel to Governor Emmanuel told journalists that the petitioner had failed to establish there was substantial malpractice that could warrant cancellation of the election. He said the petitioner, who closed his case last week, only succeeded in showing the tribunal he had no case. More witnesses of the defendants are expected at the tribunal when it reconvenes. On July the 16th, 2015, 3 days after he was relieved of his post as the National Security Advisor, retired Colonel Sambo Dasuki's residences in Abuja and Sokoto were raided by operatives of the Department of State Services, leading to his detention and release shortly after. More than a month later, Colonel Dasuki arrived in the company of family and friends to answer charges of illegal possession of firearms filed against him by the Department of State Services. According to the charges, different makes of firearms, including 5 Tabor assault rifles, 1 macro Uzi gun, 20 ammunition magazines, APG caliber gun, Luger gun, small magazine containing 16 rounds of ammunition, bigger magazine containing live rounds of ammunition, and 36 rounds of live ammunition were found on the former Security National Advisor, who pleaded not guilty to the charge. Having taken his plea, his lawyer, Mr. Joseph Daudu, made an application for his bail on self-recognition. He argued that the accused has served the country in a sensitive position in the past, and any fear that he will abscond is a non-issue because his travel documents are with the Department of State Services. The application was not opposed by the prosecution. Justice Adeniyi Ademola admitted Colonel Dasuki to bail pending the determination of the suit.
The charge was read. 1 count charge of illegal possession of firearms. He pleaded not guilty. The court took the application in writing for bail, and after a well-considered ruling, he granted bail on his self-recognizance, meaning on his self-esteem.
He is, however, directed to deposit his travel documents with the Deputy Chief Registrar of the court, and if they are in the possession of any government agency, they should be submitted to the court. The case was adjourned to October the 26th, 2015. The Court of Appeal has reserved judgment in the 3 separate appeals filed before it by the People's Democratic Party and its governorship candidate Nyesom Wike. The appellate court reserved judgment after hearing counsel from both sides in the disputed April the 11th governorship election in Rivers State. Wike and the People's Democratic Party, among other things, are asking the Court of Appeal to set aside the ruling of the State Governorship Election Petitions Tribunal, which held that it has power to sit in Abuja instead of Port Harcourt, the Rivers State capital, for security reasons. They've also asked the Court of Appeal to set aside the permission granted the All Progressive Congress and its governorship candidate Dakuku Peter side to inspect the ballot papers, voter registers, result sheets and other election materials used by the Independent National Electoral Commission for the April the 11th governorship poll. Also, the appellants want the Court of Appeal to determine whether the tribunal was properly constituted by the President of the Court of Appeal, Justice Dana Bulkachua. At the hearing of the three appeals, counsel to Governor Wike, Emmanuel Okala, asked the Court of Appeal to rule in his favor on the grounds that the tribunal was wrong in granting permission to inspect election materials without giving them adequate notice. The counsel also argued that the Court of Appeal should hold that the tribunal has no power to sit in Abuja, but in Rivers State, where the disputed election was conducted. But in his opinion, counsel to the All Progressives Congress and its governorship candidate, Akin Olujimi, urged the Court of Appeal to dismiss the appeals on the ground that they lack merit and substance. Justice Abubakar Yahaya, after hearing both parties, stated that the date for judgment will be communicated to them. The appeal court has ordered a retrial of the case challenging the election of Dino Melaye as the senator-elect representing Kogi West Senatorial District. The court stated that the case be remitted to the National Assembly Election Petition Tribunal sitting in Lokoja, Kogi State, and must be heard on an accelerated basis and determined on its merit within the remaining time stipulated by the Constitution. The tribunal had, in a 6-hour sitting, refused to set aside a motion by Senator Dino Melaye's counsel asking the tribunal to set aside the prayer of Senator Smart Adeyemi on pre-election matters and late filing. The tribunal agreed to hear the prayer of Senator Adeyemi that Senator Melaye never participated in the APC primaries, which was confirmed by INEC in a letter dated April the 30th, 2015. Earlier, the National Assembly Election Petition Tribunal sitting in Lokoja had struck out the petition filed by Senator Adeyemi on technical grounds. The petitioner therefore headed to the Court of Appeal, where there was an order for retrial, and specifically returned the petition to the Justice Akon Ekpeme-led panel. President Muhammadu Buhari's anti-graft crusade may be garnering more support as both lawmakers and civil rights activists push for the establishment of a special court for trying public fund looters. While the lawmakers advocate a special court to try looters, a civil rights activist, Mr. Oliver Ezeala, is canvassing for the death penalty for looters. He said the death sentence is the solution to endemic corruption in the country.